Indeed, as Diana already said, I visited Bulgaria a few weeks ago because the Commission always explains to us that the pilot project at the borders in Bulgaria is an important, let's say, project to also assess how the new asylum pact will be implemented and will work. So that created my interest in going there. I went to Pastrokor, where the accelerated procedures take place. But I also visit several spots at the border, spoke with Frontex and border police. And later on, while explaining the pact as it stands now, or where we have to vote tonight, I will come back to what I think would be the consequences also for Bulgaria if this pact will be adopted. So, as Diana already said, we have negotiated for a few years already on these Commission proposals, which were presented by the Commission in 2020. But some of them even date further back, as they were already part of a pact proposal in 2016. So that shows that it has appeared very difficult for the member states to agree on new internal rules in the EU on asylum. The European Parliament was always quite ambitious and also took the position that there should be a shared responsibility for asylum seekers and clear high standards for the procedure to ensure the non-refoulement principle and access to an asylum procedure. But what we see now with the ongoing negotiations that happened is that the Parliament lost a lot of its position to the favor actually of the position of the Council. So the Council had a quite different stance than the European Parliament. And I think we can only conclude that the Council has more or less won these negotiations. I will go one by one in the order of how the procedure works as to what is now the content of the laws and what are the specific characteristics. The main change, and that's a completely new system, is that if an irregular migrant arrives at the border of a country, at the external border, then he or she will be subject to a screening procedure. Of course, Schengen Borders Code already has this kind of screening, but it's very much left to the member states how they deal with this. By the way, congratulations with the accession to Schengen. And that would also mean, of course, that Bulgaria has to implement fully fledged now this whole asylum pact, because it's one part is Schengen, the other is Dublin, and then the other is asylum. So many different regimes come together. So in the screening regulation, which is actually a Schengen-related instrument, people will be subject to a screening of 7 days, and there will be a check on their identity, their security, their vulnerability, and there will be questions and gathering of information about the way that they traveled into the EU, so the travel route. On this basis, there will be a decision on where to refer the person to refer the person to the border procedure or to the normal procedure, asylum procedure on the territory. So it's important that people are sufficiently informed beforehand of the consequences of being there and their rights. So there is also this obligation that there is a way of counseling, and there should also be a special representative in case of unaccompanied minors. not yet a specific guardian, but someone who's coming from a specialized organization to defend their interest, to act on behalf of their interest. What is specific here is that during the screening procedure, the fiction of non-entry is being applied. And so that means that, we pretend that the person has not yet entered the territory, although the normal national and European legislation is applicable. But it implies sort of that people are detained. It's not explicitly in the text, but what is in the text is that people can be obliged to stay available in specific locations. And so that would already apply a sort of detention. And I think, in addition, the fiction of non-entry makes it even more probable that they will be detained. There are two other things that are important. There is the obligation for the member state to set up a monitor mechanism to monitor the fundamental rights compliance. And the commissioner always said during the presentation of her proposals that this would prevent pushbacks. But if you look at the text proposal, you see that this monitor mechanism only applies at the screening procedure itself. So it does not fully guarantee that people who arrive at the borders will be referred to the screening procedure. This is why the Parliament advocated and had it in its legislative text that it should also apply this monitor mechanism to the border surveillance area. Well, we did not manage to get that in, so this can be a discussion or a fight at the national level, because member states are always allowed to expand the scope of this monitor mechanism. Another element, which is maybe less relevant for Bulgaria, but still, is that screening can also take place on the territory. And then I think that the legislators were thinking more of in member states not bordering the external geographical borders. So if there is a suspicion that they crossed the external borders without permission, so unauthorized, they can be apprehended and sent to a screening procedure still. And I'm afraid that this may also fuel ethnic profiling, because when do you think that someone may have entered the territory on an irregular basis? So these are the most important things of the screening procedure. So then afterwards, people could be referred to a border procedure. That would mean that they have to stay at the external border, and that member states are imposing an accelerated asylum procedure. And this is regulated in the Asylum Procedures Regulation. And there you see that this is mandatory, this border procedure, for people who come from a country where the recognition rate is lower than 20%, but also in case the asylum seeker has misled the authorities by handing over false documents or not having the right documents in place. And I find this one even more worrying, because we know, as a matter of fact, that most of the asylum seekers are not capable of having official documents with them. Another mandatory ground is if there's a threat to public policy or public security. But there's also a may clause, so member states are allowed to also use the border procedure for asylum seekers, for instance, who traveled through a third country that they have declared safe. And I know that in Bulgaria, there's now also the proposal or the intention to put, for instance, Turkey at a list of safe third countries. In that regard, it's also important to note that in the asylum procedure regulation, the criteria for what is a safe third country is significantly watered down. It's lowered. Now you still have the obligation that the country complies with the relevant conventions on paper, or at least in practice. But now it will be even enough if a government of such a country declares that it complies, despite, practice that may be different. So it will become more easy to send people back to a third country where they, where they are supposed to ask for asylum and have a proper asylum procedure. There is still one other criteria, and this is there should be a connection with a third country. Some countries really wanted to have no connection at all, but at least there is now, as a minimum standard, that people must have transited through the country, so that they must have traveled through the country. But that's a very minimum criteria. And if you look, for instance, at how Greece is now using the safe third country concept for Turkey, you see it also applies to many nationalities, including Afghans, Iraqi, where we know from many reports that they do not have access to an asylum procedure in Turkey, and that they can be at any moment be apprehended and deported back. So this is a very worrying consequences. There is still in the asylum procedure regulation that the third country must readmit that person, which is now not the case also for Turkey. In Greece, it leads actually to violations of this principle, because people are declared inadmissible anyhow. So this is not an obligation for a border country, but a possibility to use the border procedure, also for safe countries of origin. How does this border procedure look like? There are 3 months for the asylum border procedure, so in which an accelerated procedure takes place. We try to get the obligation for legal aid during that procedure before the decision is taken, but it's now worded as counseling, legal counseling, and that is lower, that has a lower standard than legal aid. And we have to find out in practice what the criteria exactly will be for that. Again, there, people still are subjected to the fiction of non-entry. Also here, there's no explicit detention mentioned. We know from the Reception Conditions Directive that there always has to be an individual ground to be detained, but we expect that fiction of non-entry may be also used as an argument to keep people detained. If a rejection is being made in that 3 months, the border procedure will transfer into a border return procedure. So also of 3 months. So that means in total that they can be held for 6 months at the detention in the detention centers at the border. We, as a parliament, we wanted to have an exception for children so that they are not in these border procedure. But in the end, during the negotiations, it has been agreed that for families, this procedure also applies. The only one who are excluded are unaccompanied minors, unless they form a threat to public policy. So that's it. And if people cannot be returned within those 3 months, they have to be granted access to the territory for the normal return procedure. Then the crisis regulation. This is an important one because it actually creates a lot of derogations from the standards that this whole pact has agreed upon. in three specific situations, like if there's a crisis situation, meaning there are all of a sudden many people, if there's force majeure, it's not really clearly defined. It's just, you know, examples like COVID crisis or a disaster, natural disasters, things like that. Or in case a country is being instrumentalized, for instance, in your case, if Turkey would send migrants to the border in order to blackmail or whatever, then this crisis regulation can also be applied. And then there's no criteria on the number. So it can be 10 people, and then that could trigger the ground for instrumentalization and the crisis regulation. And that means that the border procedure will be prolonged. It will then be 20 weeks for the asylum procedure and 20 weeks for the return procedure. Plus, a member state has 4 weeks time to register a person. So in that sense, another month additional, probably. But also there are many derogations. And this border procedure will apply to many more people. In case of a crisis, for instance, the recognition rate will go from 20 to 50%. And in situations of instrumentalization, everyone will be subject to the return procedure, no matter where they come from. And there are many derogations in terms of more simplified return procedures, less procedural guarantees, etc. And this is also for the accelerated procedure. For the normal accelerated procedure, there's no automatic suspensive effect in case of an appeal. In many situations, in many derogations, you need to apply for a provisional measure in order to stay in the country before the judge has dealt with the appeal. So crisis regulation is actually is expanding the border procedure a lot, and is sort of undermining, in my view, the common standards that we have reached on reception, qualification, return, on all the elements of the asylum system. So these are actually all more additional obligations in most of the cases for the external border countries, for the countries at the external borders. And then, of course, the countries at the external borders wanted to have more safeguards for a shared responsibility for the asylum seekers. And also we as a parliament, we wanted to have, more obligations for transfer of asylum seekers in a proportionate way. But if you look at the result, the first entry criteria remains. So it means that the country where the asylum seeker comes in stays responsible, and even for a longer period than now. It will be up to 20 months, I believe. I have to check, but something like that. So it will be longer. There will be, in times of migration pressure, and then there's a very bureaucratic procedure in which it will be decided. It's very opaque because it's not transparent. The Commission does a proposal to the Council, and the Council makes a decision. Then, if it's decided that a country is under migration pressure, a mandatory solidarity kicks in. But with that mandatory solidarity, member states can still choose how to show solidarity. They can relocate people, but they can also pay off their obligation, 10,000 euros for one asylum seeker. They can also do a financial contribution for walls, for fences, but even also for border control in third countries. And they can also help, assisting in returns of people, for instance, through diplomatic cooperation with third countries. So it's quite a permissive solidarity obligation, I would say. And that means there's no guarantee that it will be more proportionately divided. There is one mitigating measure, I would say, if there is a really insufficient amount of relocations, then the so-called Dublin offset is applicable. That means that member states cannot transfer or do a Dublin claim anymore to the country of first entry. So then they have to process the asylum seekers themselves. But it's limited, and we still have to see and find out how this will work in practice. Then we have the Eurodac regulation. We already have Eurodac regulation meant to gather biometric data, fingerprints, for determining which country is responsible. But this database will now also be open for police, for the justice authorities, for police investigations and whatever. And the age will be lowered from 14 years to the age of 6 years that asylum seekers are obliged to give their biometric data. The recast reception conditions directive, it's the only one that is still a directive and not a regulation. This introduces more limitations to the freedom of asylum seekers, but there's one important safeguard for minors, because the recast says that as a rule, minors shall not be detained. And then there's an exception, unless it's in their own interest. So we have to see how that in the end plays out, but at least it's better than what we have now, because now there's no specific concrete prohibition to detain minors. Yeah, and then we still have a resettlement regulation. This is also completely new, but it doesn't oblige member states to resettle. It's just harmonizing the procedures. And we have a qualification regulation, which is also changing a few elements of the qualification directive, notably, for instance, the obligation for a member state to assess if a part of a country is safe, if not the whole country is safe, and the obligation to withdraw protection in certain situations. So that's a bit the whole picture. What it specifically would mean for Bulgaria, I already mentioned a few things. When I visited Pastrogor, I also observed that it's not a detained situation, and that people who work there also expressed their concerns that because they don't want it to transfer it into a detention center. So I think that may be one of the topics that will be discussed while implementing the pact, if that's necessary, and if so, how. There will be this obligation, of course, for doing the screening, for the registering, and the border procedures. There will be also more funding, also for the implementation, and also for the agencies to support I think specifically the countries at the external borders. But it will definitely take a lot more capacity. It will take capacity on immigration officers, because EUAA cannot make decisions for legal aid, for judges. I think it has a large amount of implications for the whole chain, actually. And those with a low recognition rate will stay at the external border, which also means a higher responsibility for those countries to return people. So then it may even become more important to have a good cooperation with countries of origin, and also, being faced with more difficulties if that is not the case. I can imagine that this whole system, if the pact, gives the impression that there's a balance between responsibility and solidarity. But if you look at the possibilities for other member states to evade their obligation, their responsibility to show genuine solidarity, then I'm afraid that the bigger tasks for countries at the external borders may also imply more attempts to also evade and circumvent their obligations. For instance, with pushbacks, which are not, we don't have an obligation to monitor the fundamental rights obligations at the border. With, for instance, having substandard conditions so that people will travel onward, in the hope then that there will be this Dublin offset that member states cannot return the people. There are a lot of concerns which are still not completely clear. There will be now an implementation plan being also designed by the Commission in cooperation with the member states. And I can just, advise you, be involved from the very first start of thinking about this whole pact, because many definitions are unclear. It's really important to define. It's also important to have sufficient procedural guarantees, because if you don't have a good quality of a procedure, you will have appeals. You will have a big risk of non-refoulement. I don't think I need to tell you that. So, and I hope in the end that the member states will also make sure it will be harmonized, so that there's not a lot of big differences between the member states, because then we will end up like we do now, with less compliance with the rules and with trying to be less attractive than another member states, at the cost, of course, of the asylum seeker trying to find a place of protection in the EU. Maybe I spoke already too long, but hopefully it was informative. Thank you very much for the attention.